Hi everyone, let me introduce myself. My name is Paula D. Azevedo. I work at IC Clark Attorneys. I'm a director here. I am also the secretary of the Attorneys Association, so if you are looking for a job and you're looking for help, somebody to send a CV to distribute to all the attorneys in the East London and Dunsany area, that person would be me. So let me first give you my email address. So if you are looking, please do send me your CV. I will then circulate it for you. I will confirm that I've circulated it. My email address is paula@icclark.co.za. That's paula@icclark.co.za. Also, if you have any questions regarding this lecture or anything that I've said, or if you're not certain about anything, please also do send me an email. I know that we're doing things differently this year with COVID and all of that and social distancing, but I do encourage you, if you have any questions, please do send me an email and I'll get back to you. So the first thing that I would like to say is that I don't set your papers. So whatever I do say here today should not be construed as the only thing that you'd be asked about. Please do read through all your notes, and more importantly, at the beginning of every chapter you have that outcome block which says or lists the things that you need to know from the chapter. Please do, when you read through the chapter, make sure that you go down the list and make sure you check and you say, yes, I can answer this question, I can answer this question. Also, at the back of your notes, there are certain forms there as well, and precedents. Please do look at those, but also practice the drafting side of things. Majority of the questions, whether it's draft particulars of claim, it doesn't matter what field of law it is, the particulars of claim sort of remains the same. Who's the plaintiff, who's the defendant, whole cause of action, jurisdiction, what your prayers are, things like that. So just follow the set pattern and stick to the facts, and then you will be fine. So where do we start? The first thing that I normally like to ask people is, do you think that you can sue for breach of promise to marry? And I know a lot of people say yes, and some people say no. There are two cases that I would refer you to, and that would be the case of Van Jaarsveld versus Bridger and Klutter versus Moritz. And in Jaarsveld versus Bridger, that is a 2010 case. In that matter, a farmer became engaged in 2005 to his girlfriend at the time, and the marriage was set for January 2006. He then sent her an SMS breaking up with her, and I'm sure he was very, very scared to do it face to face, so he chickened out and sent an SMS. And so what she did was she sued him for breach of contract as well as inuria. And the court found that, number one, she didn't suffer any financial loss, and that his text message was not didn't injure her in any way, or defame her or whatever. So it was very objective. They then held that the world has moved on, and morals have changed, there was nothing injurious in the way that he broke up with her. So that is Van Jaarsveld. And in the matter of Klute versus Moretz, this is a 2013 case, and this couple had been together for many, many years. They had an oral agreement in 1988 that they would get married within a reasonable period of time. And in 1999, they got engaged. And then in 2009, the defendant then broke it off. So in this particular matter, the plaintiff wanted to sue for, or a claim for what she would have had the agreement gone through, had the contract been fulfilled. So that would be the use of immovable property, it would be maintenance, and there the court held that you cannot hold a party liable for contractual damages for the breach of promise, because this would then lead to a situation where people are forced to proceed with marriages and enter into this marriage for fear of being sued for the repudiation of the agreement. So that was that. So I hope that answers any of your questions. The next thing we're going to look at is the what regulates the civil marriages. Firstly, we're looking at the Marriages Act 25 of 1961 and the Civil Union Act 17 of 2006. So when you think formalities, I like to have like a list of 5 things, and I think to myself, okay, it has to be, in terms of the Marriages Act now, not the Civil Union Act, the Marriages Act, it has to be between a man and a woman. It has to be solemnized by somebody that has been duly authorized and legally appointed to do so. The parties have to be over the age of 18, that's number 3. And if they are not, what happens in that case? So you would know that either they would have the consent of the parents, the guardian. In some cases it would be the Minister of Home Affairs, and if not, then they can approach the High Court as upper guardians. So that's point 3. And then just to make it easier to remember, point 4, the ceremony must be concluded in a building with open doors, and this used to be rigidly enforced, but in 1987, in the matter of ex parte do, this is point 5. Now, whenever you think, okay, it has to be concluded in a building with open doors, then you think about, okay, no, some people do get married, on the beach, in the garden, and all of that. So the 5th point would be ex parte do. This is the 1987 matter where the parties brought a declaratory, rather an application for a declaratory order, because they had been married in a private home in the garden, and the court held that non-compliance with the formalities did not lead to the marriage being void. It didn't lead to a nullity. So that's ex parte do. And then obviously we have the Recognition of Customary Marriages Act 120 of 1998. This came into effect on the 15th of November 2000. Now, just remember that this is very important, the date, because I know sometimes you look at an act and you think 1998, and you think it came into operation, at that time. But just remember the date, 15 November 2000, because if a question is posed to you about a marriage a customary marriage that was concluded, let's say in January of 2000, you need to know how that marriage, what the consequences of that marriage would have been, and what it would have been after the recognition of Customary Marriages Act. Another thing is, why is it called the Recognition of Customary Marriages Act? Why do you think? It's clearly because it wasn't recognized, before. Okay, so this would conclude that prior to the recognition of Marriages Act, if parties got married customarily, and one of the parties then went to conclude a civil marriage, that customary marriage, because it is not recognized, would be null and void. So this was very important for customary marriages to be recognized and for the act to come into effect. So it is quite important. Also, what is customary marriage? What is it? It is a marriage concluded in terms of customary law, which means that it has to be celebrated in terms of the customs and the traditions and usages of the indigenous people of South Africa. That is your textbook definition. Now, what are the formalities of that kind of marriage? The parties have to consent to be married in this way, or rather consent to being married customarily. The parties have to be over the age of 18, and if not, then it would be the same as in terms of the Marriages Act, where you would get the consent of your parents or your guardians, if not the Minister of Home Affairs in some instances, and if not, then the High Court as upper guardian. The marriage will then have to be celebrated and negotiated in terms of the tradition and the custom. And if there is one couple involved, then they can also enter the marriage under the Marriages Act. It would then be registered within 3 months. In 2013, the Constitutional Court held that the first wife will have to consent to any subsequent marriage. So I always like to ask people what they think about that, because clearly before the consent was not needed, and are people okay with changing custom? So there have been a lot of changes to customary law through the Act and through case law as well. So it's quite an interesting question to ask people whether they agree to the changes, or is that in itself not changing customs. So we have spoken about now what happens with being married before the recognition of Customary Marriages Act, and what happens if somebody then goes and concludes a civil marriage, and that is obviously prior to the Customary Marriages Act. Then we're taking a look at the different forms of marital dispensations. We know that there's in community of property. We know that there is out of community of property, including accrual and excluding accrual. In community of property, I think that we all know what that is. It's 50-50. You share in profits and losses, and it's one that could get people in trouble. We've seen it so often where, you know, people would live their lives, they would work so hard for their pension, and when it came time to retire, there would be a divorce, and then the one spouse would then, you know, claim half of the pension, half of the house, and then you know, for $1 million, if your pension's $1 million, you have to now split it two ways, 500,000, and you're at retirement age. What do you do? So yeah, so that's also quite dangerous, because what if your spouse goes and incurs a lot of debt as well, and you don't know about it? This could lead to problems. So then we have out of community of property excluding accrual, which is actually the one that I favor. It's not the most popular one. This is the one that I favor the most. So the danger with this one is that sometimes parties will come to an agreement, and they will say that, okay, I will pay the bond of the property, and the property will be in my name, and you will contribute towards the groceries and paying the electricity bill and all of that. But in essence, it means that the property belongs to me, and my partner will have no claim, even though they have contributed towards groceries all the years, etc. No, they will have no claim. They would have to purchase the property together if that person that was paying for the groceries would like to claim anything. This one here, you can have a verbal agreement for an ANC. The question would then be, one party would have to then prove that it was indeed excluding accrual. There was the matter of Odendaal versus Odendaal, where the parties entered into a verbal antenuptial contract. The one party said no, it was a marriage out of community of property, including accrual, and the other one said no, it was, I agree that there was a verbal agreement, however, it was excluding accrual. So you have one saying it's in and the other one saying it's out. So in that situation, the court then held that if the parties then agree that there was a verbal ANC that took place, they would go for the less harsher one, which would then be the marriage was then declared, the marriage was in accrual. Okay, and then there was also the matter of Bath versus Bath, where the parties entered into an ANC, however it was very vague, and it was therefore, the court held the parties were married in community of property because it was void for vagueness, basically. So you have to be very careful with that. So yeah, out of community, excluding accrual, what's yours is yours, what's your partner's is your partner's. Another thing that people don't really know, I will get to this a little bit later, but some people don't know though that a party can still claim for maintenance even if they were married, excluding accrual. But of course, remember that a spouse is not entitled to maintenance. They don't have a right to maintenance. The court has a discretion to award this, and the party would have to show that they need this maintenance, and it would be a rehabilitative kind of maintenance for 6 months, for a year, or whatever, depending on the case. So a spouse can still, even if they are married, out of community of property, excluding accrual, can still be ordered to pay maintenance. Not a lot of people know that, so that's why they choose this kind of marriage, because they think that, you know, when they get divorced, it's just going to be clear cut. So that's just another thing. The other one is being married including accrual. This is now the preferred one, the most popular regime, and the net values are determined separately in this matter. So let's say I started with 100,000 and my partner started with 0. And during the course of the marriage, I have 500,000 and he still has 0. Then you would then deduct the commencement value updated for inflation, etc. So I will tell you how we do that. You're going to draft a list of each of both parties' assets and liabilities. Sorry, not liabilities, just assets. And then you are going to deduct the commencement values of the parties. So draft a list of the assets, deduct the commencement value updated for inflation. You then exclude the items that were specifically mentioned in the ANC that would have been excluded. So some people specifically exclude the pension or an immovable property or whatever it is. So you will then deduct whatever is mentioned there. If there's nothing mentioned, then that's fine. But if there is something mentioned there, you add that in there as well. Then you exclude legacies, donations, inheritance. You exclude any general damages that were paid for maybe a medical negligence claim or a road accident fund or whatever, because that's for pain and suffering. So that will not be included there. And then you deduct then you deduct their debts, and then you see what the calculation is then. Okay, so that is how you determine that. So let's say now, with that example, I had 100,000 and I have now 500,000 and he still has 0. And I was married a year ago, or even this year, for instance. You would then take my 500 less the commencement value and then divide that by 2. Then you will see what the figure is. All right, and so then there's that. Antenuptial contracts, they can be drafted by attorneys, but they are executed before a notary before the marriage. You have to sign an indemnity. The client has to sign an indemnity to say that they have been explained about the different marital regimes, and that this is the one that they are choosing. So you then sign it in duplicate, you send it to the deeds office, you pay a fee, a registration fee, and then once the original comes back, you then hand it, endorsed from the deeds office, you then hand it to the client, the original. Okay, so if you need to register it late, you can bring an application, an ex parte application for condonation within a reasonable period of time, and you have to give notice to the deeds office of your intention to bring such an application. So that is something that is able to be done. And just remember that a postnuptial agreement without the court's intervention is not enforceable. but between the parties. Okay, so we've done that, and now I'm going to discuss the change of marital regime. This was a very interesting one for me, especially because when I was doing articles and I was allowed to do my first consultation, this is the one that I got, and which I think is quite a difficult one for a candidate. If a client comes in and says, listen, I want to, I'm married, but I want to change my marital regime, how do I go about it? So yes, you have everything written down, and but how do you actually go about it? And so yes, so I'm going to discuss that next.